Hey everyone, welcome to our conversations with experts. Today we have a great interview with two legal experts. I've been close to these guys for a while. I'm really excited to chat with them and bring you a lot of knowledge that you can use in businesses. Today we have Avid Legal co-founders Jason Stark and Sean Melvin. Jason, give us a little bit of background on the firm and what you're trying to do, and then some background on yourself.
Yeah, absolutely. So our focus is startups and small and medium-sized businesses on the transactional and corporate side. So we don't sue anyone; we focus on deals. And within that, we have a focus on venture capital, which I think of as under 50% investments in companies where somebody's taking an investment but they're not running the show. Mergers and acquisitions, which would either be buying a company entirely or at least a controlling interest. And then also hospitality, which is more like restaurants and hotels, and also real estate transactions. We also work with investment funds.
Awesome.
Yeah. And as far as our experience goes, so I'm originally a CPA, like the guys at ProSeer, but it's long in the rearview mirror. I work solely as a kind of a small business lawyer these days. Sean, similar background, and we have a third partner who focuses more on mergers and acquisitions.
Awesome. Sean, how about you? You recently joined up with Jason. Tell us a little bit about yourself and your background.
Yeah, thanks, Jeff. Always good to see you. So Jason and I have known each other for 20 plus years at this point. We've each been partners in boutique law firms, and we joined forces almost 6 months ago with our third partner, John Crivelli, to form Avid Legal, with the idea being that we would be a boutique business transactional law firm, like Jason said, handling all types of mergers and acquisitions, venture capital deals, and just general corporate transactional matters. I've been practicing law for a little over 15 years now, and I have a background in a combination of business transactional matters and some commercial litigation. So I'm no longer litigating, but I like to leverage my background in litigation to help clients figure out how to avoid litigation.
Awesome. Yeah, that's definitely the goal for sure. As we're working with our clients as well, litigation is kind of the last resort. So, now all of us here work with startups and small and medium sized businesses, and one of the first questions that any entrepreneur has is around structuring their company from a legal standpoint. Jason, can you kind of walk us through what are the considerations that an entrepreneur should think through when it comes to legal entity structure? What are the pros and cons of the various structures as well?
Yeah, and the primary considerations are legal liability and tax. I think Sean will go into the liability a little bit. I'll touch on the tax. So it's very nuanced, but I guess I look at it in terms of what is your business doing. So the primary ways to form are either with an LLC, tax as a partnership, an S corp, or a C corp. So S corps are fairly limited in that you can only have 100 shareholders. They have to be non-entities, and they have to be U.S. based. So you really can't use that if you're going to be accepting venture investment. If it's more of a service company, if you're a group of architects or something like that, S corp's perfect. And there's some benefits also on the on payroll taxes for using that structure. Corporations, they have this inherent problem of what we call the double tax. They're taxed at the entity level, and there's tax. If there's profits for the ordinary business of the company on a yearly basis, and then if you make distributions, there's a whole nother level of tax, and that also applies out to the exit and the sale of the company. However, there's some situations in which you really do need a corporation, especially venture-backed companies and tech companies. A lot of investors just require it. They can't necessarily accept pass-through income if they're tax exempt. They also, would have UBTI, unrelated business taxable income issues. So, the C corp structure is very popular and used most frequently in the tech startup world, and in huge public companies too. Um, the rest of the universe typically falls into the LLC bucket. LLCs are extremely flexible. You can have investors in LLCs if they're okay with pass-through income. Founders and investors can have different distribution mechanisms. Well, one thing I neglected to mention about S corps also is they can only have one class of stock. Everyone has to be treated essentially the same on a pro rata basis, depending on the number of shares they hold. Whereas LLCs have ultimate flexibility. You can give different profit and loss allocations to the members who are taxed at the entity level, so that the investors actually receive the losses if you're operating at a loss, or the profits in a profit situation. It's a little bit more difficult than in a C corp to structure equity investment for the employees, but it's doable. There's this structure called profits interest where the employee is only taxed on capital gains but they can only receive the value of the company as of the date they come into the company. So it's a little bit complicated, but these structures, you always want to start by having a good conversation with, your internal team, service providers, accountants, lawyers, etc. But if you start by thinking of kind of the category of what your business is, I think it really helps you to kind of steer in the right direction. And another one I neglected to mention are partnerships. Those aren't used too frequently, but they're very similar to LLCs. Investment funds are almost always structured as partnerships.
Awesome. Thank you.
And I can touch on that a little bit, Jeff. Also, as you're well aware, obviously in your practice at ProSierra, and as Jason mentioned, there's a good amount of complexity and nuance that comes into these decisions as far as choice of entity. But I like to I want to clear up one thing that I think is a sort of a misconception that a lot of people have, or a point of misunderstanding or confusion. There's taking a kind of a step back, forgetting all the nuance for a minute. Let's take a 30,000 foot overview of choice of entity. There's a distinction between the type of entity that is formed under state law and the federal tax designation. And I think a lot of people really don't understand that distinction. And I think it's a really important distinction. When Jason was answering your question, he made a comment. I think he used the phrase an LLC taxed as a partnership. So very often you'll have someone say that, my entity is an S corp. Well, you can have a corporation taxed as an S corp. You can also have an LLC taxed as an S corp. So when I say the corporation taxed as the S corp, corporation is the type of entity under state law. Taxed as an S corp is that S corp election that's made for federal tax purposes. There's quite a few different entities under state law, and from we practice primarily in Florida, and we handle a significant number of Delaware entities as well. And typically, what you see, at least under the laws of those two states, and pretty much every other state, you have corporations, you have LLCs, which are limited liability companies. You have partnerships, you have limited partnerships. There's limited liability, limited partnerships. There's a whole bunch of different types of entities under state law, but typically, what you see are corporations and LLCs under state law. And then all the different types of entities Jason really referred to are the types of federal tax designations. Just again, without getting into all the nuance, a multi-member, meaning more than one member LLC by default is taxed as a partnership, but can choose an S corp election. So there's quite a decent variety of combinations as to how that can play out. The other point I'll mention really quickly, anyone can, for the most part, there's obviously certain requirements, but anyone for the most part can just start operating a business without forming an entity, and it would be considered what's called the sole proprietorship. In that situation, you personally are fully liable for any debts or liabilities of that business. It's really never a good idea to operate a business as a sole proprietorship. So all these different types of state law entities that we're talking about, again, primarily corporations and LLCs, bring with them some degree of limited liability protection from creditors for different types of liabilities. And it's a much more complicated conversation depending on what type of business we're talking about, what the risk factors are. That's the sort of thing that we counsel our clients on. But a huge part of the choice of entity is also trying to limit liability to the greatest extent possible.
Awesome. And so let's just dive in a little bit more, a little deeper on that. When we talk about protections, Sean, you started to going in a little bit of examples, but what are we trying to protect from? Who are we trying to protect when we set up an entity?
Sure, and it's a really there's a very broad range of potential liabilities. So I guess a good way of looking at it would be protection from claims of creditors. So I'll give you a good example, Jeff. If you form a company and you go sign a lease for commercial real estate, assuming your landlord doesn't ask for a personal guarantee, which is a whole separate story, but if you form an LLC or a corporation and you observe the proper corporate formalities, which means, again, it's more nuanced, but it essentially means that you treat the business as a separate and distinct entity from you personally. And that LLC signs the lease agreement. If there's an issue down the road and the LLC doesn't have enough money to pay the rent and the landlord sues for eviction and for monetary damages, generally speaking, the individual owners, the members of that LLC are going to be protected from personal liability if they're conducting business through the entity, which also, brings me to an important point that I think a lot of people, unless you really have experience, dealing with legal matters, you may not realize that there's a significant distinction in the capacity in which you sign a document. So it's very important to really understand when you're signing a piece of paper, are you signing it personally in your own individual capacity, or are you signing it on behalf of an entity that you have the right to bind to that agreement? So, I think that, again, the first point is really protection from creditors. And the other point could be protection, against potential liability in tort, which would be negligence type of cases, slip and falls, that sort of thing. People are still liable for their own negligence, their own culpability, but generally speaking, doing business through an entity is going to provide the owners of that entity with the degree of protection from personal liability.
Awesome. Yeah, that's very clear. It makes sense. On the other side is goals from a growth and investment perspective. Jason, you mentioned that a little bit about kind of the buckets of different types of vehicles that might be used for the goals of the entrepreneur. Can you talk about how different entity structures might be used for taking investment versus, taking friends and family rounds, or just growing a business organically and bootstrap? What are those buckets, and how should an entrepreneur think about which bucket they might fall in?
Yeah. So that's where we get into just like you said, the type of business. If you think you're going to be eventually purchased, then that's where we probably don't want to use the S corp. That's where you want to look at LLC or straight C corporation. Now, if one thing I always say is, if you're on the fence, go with the LLC, because it's very difficult to get out of a C corp. If you just started and there's not much value in the company, you might be able to get out. Because when I say get out, it means when you exit a C corp, you're paying tax on basically the value of that company. So you don't want to do it if the company has a lot of value. So if you're on the fence, go with the LLC. It's usually not very difficult to then switch it over to a C corp. If you're going to have institutional investors like funds, you probably need to go the C corp route. But if you don't know where you're going to end up, because there's getting back to those buckets, I look at it as your traditional mom and pop business, where you might be looking to grow to 1 million, 10 million, whatever, with the people that you started it with, or what we think of as organic growth, just growing sales, growing the business over time with really the same owners. Or venture backed, where you're taking money from friends and family and other people. They're two very different things. If you just have 3 people you're starting the business with, then and you're going to keep it that way, it's very easy to go with the LLC route, and that's probably your best bet. If you're going to be raising, if you're a tech startup and you're just burning cash like crazy, you need money to, build some complicated tech product, or, if you're in healthcare to build some biotech product, then you should probably be a C corp. That's kind of like the general nuances of it.
What makes a C corp a better vehicle for someone looking to go and raise venture capital?
Yeah, so there's a handful of things. There's one thing called the small business exemption, section 1202 of the tax code. With that exemption, if you meet certain hoops, certain requirements, you can't have a company worth over 50 million. You can only do so many redemptions of your stock. And the key thing is holding the stock for 5 years. You can sell your stock and not pay capital gains. So really nice incentive for people investing in these type of companies. There's, as I mentioned earlier, it's a little bit of an easier structure to do employee equity. We could go on and on about the nuances of 409A and issuing stock to employees, but it's just easier in a C corp than an LLC. As I mentioned, some investors just require it. So it's like, well, if you want to take money from Sequoia or some venture capital fund, that's your only choice. So that's another reason to use that structure. If you thinking of the really high growth tech startups, you want to IPO, generally need to be a C corp. So if you're a C corp, you're already in that structure.
Awesome.
And also getting back to the employee thing too, as opposed to an LLC, you can have different classes of stock. So the investors get preferred stock, the founders and employees get common. And as far as the valuation of the common, it could be a lot less because the investors a lot of times ask for more sophisticated rights. A lot of times what we call a liquidation preference, meaning they get 1x return or even 2x before the employees get anything. So if you have that structure, a firm like Jeff's could come in and do a valuation. You figure out what the company's worth, and the tax hit for the employees can be much, much less than if you just had one class of stock and you were in the LLC structure.
Got it. That makes sense. Awesome. So I think we've covered entity structure pretty well, the goals around that. Obviously, speak to your attorney when forming your company to make sure you're covered and your goals are able to be accomplished in that vehicle. I want to get into an operating business. And in the scenario where a business has formed their entity, they're ready to get going, they're starting to sign contracts with vendors. Sean, what are some things that a business owner and entrepreneur wants to make sure that they have covered in a typical contract to make sure that they don't end up with any potential liability or any issues down the road? What are the common terms that you want to include?
Yeah, there's really no practical way to eliminate all risk. So I look at our role as to mitigate risk and to understand what that risk is. There's going to be risk in anything that you do. It's just the reality of life. Not to sound too cliche here, but anyone can sue anyone for anything. It's just the reality. If someone wants to file a lawsuit against you, they can. The idea is to try to protect yourself in the event of that lawsuit, to try to deter the lawsuit from being filed. And in the event that it does happen, to try to minimize your risk and maximize your probability of success. So, to really answer your question, Jeff, the number one piece of advice that I give in a situation, in contracting is clarity. It's all about clarity. It's if a third party, meaning a judge or an arbitrator, is looking at this document, it should be very clear what each side's rights and obligations are. And you'd be shocked at how often, contracts come across our desks, even written by major corporations, where as an outsider looking at this for the first time, you read the contract and you say, what does this even mean? Who's doing what here? What are you providing? What does this cost? So very often you see people get really caught up in the weeds without hitting the real important points. That being said, there are some of the weeds that you need to get caught up on. So I think, again, first and foremost, what are the parties doing? Who's doing what? What's being provided? What's being paid for? How much does it cost? How is it calculated? You really just want to have everything just as clear as you can possibly make it. Now, whole separate story. Once in a while, there are times where you want to be intentionally vague or ambiguous about it, but that's usually done for a strategic purpose. But generally, you want to be as clear as you can be. And then there are certain terms, again, depending on the type of contract you're talking about, that are the more heavily negotiated terms, or the terms that really matter the most. For example, indemnification provisions we see negotiated very often. And as a really high level overview, what that means is it's someone agreeing to cover the liability of someone else. So it's if your company is entering into a contract with some cloud-based software provider, you may want them to indemnify you in the event that you are sued by a third party for a breach of an IP right or something along those lines. So, if you're using the software product and you get sued, you want to be able to go back to the provider of the product and say, hey, this is your problem, not my problem. So that's one of the types of provisions that we very commonly negotiate, the scope of an indemnification provision. On a broader scale, if you're doing merger or an acquisition, which is a little bit different, I guess, than your question of the operational, but it's really important to be really clear on the scope of the representations and warranties that are being made in connection with that transaction. So I kind of went a little bit beyond the simple question, but basically, again, it's really all about clarity and understanding what your rights are and limiting risk.
Awesome. I want to press you on one of the things you said, though, in terms of being a little bit vague. What are the scenarios where you might want to be vague?
It's a tough one to answer. It's really a case by case type of situation. But if you are in a situation where you think there could potentially be a problem down the road and you want an out, it's sometimes not the worst idea to build in a provision that requires parties to negotiate in good faith. Things along those lines where you could have something to point to later on as a potential breach by the other party. That's one example, but it's really fact specific situation. But it does happen once in a while where we see something and there's a reason why something is intentionally vague. But that's sort of the exception to the rule. I'd say for the most part, it's really about clarity, and it's about being unambiguous, and it's about a third party being able to look at this piece of paper and understanding what each party's rights and obligations are. And again, you'd be shocked at how often you read a piece of a contract and say, this doesn't say anything, or how would a judge ever enforce this agreement? Typically, you don't want to be in that situation. So, from our point of view, it's about being proactive and not letting that happen from the onset, and avoiding that altogether. I can go on and on about how horrible litigation is and what a long dark road it is, and how no one benefits but the lawyers. So my goal is really to avoid litigation at all costs.
Awesome. That makes sense. Appreciate that explanation. So talking about staying on the contracts topic, Jason, I'd like to get an idea of what are the standard contracts that every business typically will need, whether that's NDAs, whether that's operating agreements, employee agreements, et cetera, et cetera. What are those standard agreements that every business owner, regardless of entity structure, should have in place and ready to go?
Yeah, absolutely. To take back to a point Sean mentioned about following corporate formalities in order for contracts to be business risk versus personal risk, you need to make sure not only do you incorporate, that's step one. If you're in Florida, you can go on Sunbiz. It's really easy. Like you should, getting back to another of Sean's points, if you don't do anything else, just make sure you start with an entity. There's really very little benefit to being a sole proprietorship, including, the form you file with the IRS is actually auditing a lot more. So, and for liability perspective, it's terrible. So you want to start by having some kind of corporate structure. And then in order for that to be better enforced, you want to have the right organizational documents. If it's an LLC, you need an operating agreement. If it's a corporation, you need bylaws and organizational consent, incorporator consent, some other things. So start with having the right organizational documents. If you have partners, those documents need to be more robust and more well thought out. If it's sole owner, they can be very, very simple. So that's step one, is the organizational documents. That really applies to everyone. And then depending on your business, well, I mean, most businesses have employees, so you want to have a good, offer letter that basically says employment is at will in case things don't work out with the employee. And you want to have certain protections from employees, usually confidentiality and inventions assignment agreement, meaning that all work of the employee is done for the company, not for themselves. So that IP is owned by you. You have certain, I guess I would call it commercial agreements that are specific to your business. So if you're a software company, you might have a SaaS, software as a service contract. If you're selling equipment, you might have a limited warranty that has some limited liability protections for the company. So whatever your core business is, make sure you have a good form contract for what it is. On the customer side, you're focusing on pricing and quantity and that kind of thing. From our perspective as lawyers, we really like to focus in on limitation of liability and indemnification, things that protect the company itself. Yeah, absolutely. NDAs, like you mentioned, are really important if you're going to provide any sensitive information, especially to like a bigger company who can go and then steal your idea. You want to have a good NDA if you're going to share financials, that kind of thing.
Makes sense.
Just to touch for a second on what Jason was mentioning on the organizational documents. If it's a business that has more than one founder or owner, it's really important to have a really clear understanding as far as decision making processes go. Who controls this business? Who is able to bind the company? Are there certain decisions that require either supermajority consent or unanimous consent? Things along those lines would typically be covered in those initial organizational documents, and it's pretty important to handle those early on before dispute arises.
Makes sense. Sean, do you have a favorite agreement that you like working on with your clients?
To answer your question, I think my favorite agreement is probably a settlement agreement. Once someone has asserted a claim, whether it's my client that's asserting a claim against someone else or someone else asserting a claim against my client, it's the agreement that is typically entered into to resolve that dispute. I've drafted and negotiated hundreds of settlement agreements over the years. And yeah, if I had to answer your question, what's my favorite? It's that one, because I know that in the absence of that settlement agreement, the parties are looking at a difficult situation, and that settlement agreement really puts finality to that pending dispute. Separate and apart from that, I do like doing the organizational documents as well, because it really it helps you see the formation of an entity and the initial steps that it's going through, and it's sort of helping you set the stages for that entity to grow. And it's part of what we do as lawyers representing startups and small businesses is really working with our clients to grow with them, which I know is the same thing that you all at ProSea are doing, growing with your clients, and it's really exciting to see that happen.
Absolutely awesome. On that note, on talking about formation side, we talk about partnerships, we talk about investments. Jason, from your perspective, we get this question often. Founders that are coming together to form a business, or a business that has been founded and looking to bring in maybe potential key employees and looking to allocate equity. How do you advise your clients on distributing equity or allocating equity in the early stages?
Yeah, it's a tough one because there's such a big divide as to what it could be. I mean, if you're giving out stock in Google, you're giving out 0.00001%. Whereas if you're just starting from scratch, the numbers have to be a lot higher. As if I can give like super overarching things, founders typically, depending on how many they are, usually in the 10% to all the way up to 80, 90, 100% range. Whereas key employees are usually more in the 1 to 10% range. Advisors, sometimes somebody who's like an expert in the industry, you might give them a little stock, not for really being an employee, but for being available for calls a few times a month. That's usually more in the 0.25% to 2.5% range. So really just depends on what's being offered, as many things in the business world, highly negotiable. Investors, in a very typical Series A round, it's usually somewhere in the 20% range. But obviously, that's also goes way down and way up depending on size of the investment and the value of the company.
Sure. Yeah, and I guess also one point that's important to keep in mind when you're forming the company is going back to what we talked about earlier, is what goals you have. If you're planning on taking on future investment, that relates to dilution and reduced ownership in that business over time. So making sure you get it right from the beginning is super important. So talking with advisors or attorneys who have seen a lot of transactions and understand what the market is for investments can make your life a lot easier and protect a lot more value for you in the future. So we're sticking on the employee side, Sean. What are the key considerations for a business when they're taking on starting to hire employees? We talked about disclosures. We talked about Jason mentioned making sure that the work that they complete is owned by the employer. What are some other considerations that business owners need to think about when they start hiring?
A big picture consideration is, how are you going to classify this individual? Are they going to be considered an employee or an independent contractor? Which, is also, a conversation we could spend hours talking about. It gets very detailed and nuanced. I recommend that new business owners take a little bit of time and look. There's some good resources out there through the Department of Labor, and the IRS also has some publications on this. It's not as simple as a lot of people think it is. It's not as simple as hiring someone and saying, well, I'm going to call them an independent contractor, give them a 1099, therefore they're an independent contractor. There are a host of factors that are considered in doing that analysis, and there could be some significant repercussions if you misclassify someone, both legal and tax ramifications. So it's important to really do that analysis and make sure that you're properly classifying the people that are working for your company. And then the other, really important point, and it goes back to what I was talking about a few minutes ago on just general contracting principles. It's about clarity. It's about when you hire somebody, having a written agreement. I don't want to use the phrase employment agreement because that people typically hear employment agreement and they think that that's the opposite of an at-will employment. So let me take a step back. The default, at least here in the state of Florida, is employment is at will. You don't have a guaranteed term of employment. There's no right to severance. Your employer can fire you if you're not performing your job well, or quite frankly, if they just don't like you. As long as it's not for a discriminatory purpose or in violation of law, they can terminate you. Typically, when you hear the phrase employment agreement, it's implying that there is a term of employment, meaning you're going to be guaranteed employment for a certain amount of time. Typically, in that sort of agreement, there would be provisions to be for termination for cause, and certain requirements that would be met in order to implement that provision. But what I was really getting at is, even if it's not going to be employment for a specific term, it's a good idea to have a written document between the company and the employee or the contractor setting forth the terms and conditions of that relationship. If it's at will, like Jason mentioned a few minutes ago, if it's at will, you want to have a piece of paper that really clearly says it's at will. You're being hired to do this job. Here are your job duties and responsibilities. This is your rate of pay. Here are the benefits that you're getting. You really just want to lay out the key terms of that relationship. I think that's a really important point that a lot of people just sort of overlook. And I get it. When you're starting a business, there's a lot of moving parts, a lot happening. But these are important things to really give some thought to protect yourself down the road.
Awesome. Yeah, that makes sense. It's a big decision to bring your first employees on. So definitely want to make sure you do it right. So moving forward to kind of later stage of life cycle for exit strategies for businesses. A lot of legal considerations, Jason, when we're approaching an exit. When a company comes to you and says, "Hey, we're thinking about exiting in 2, 3, 5 years," what are some big checklist items they should keep in mind and make sure they have ready to go as they approach that exit, whether that's a sale, merger, or potential IPO?
Yeah, absolutely. So first thing you want to do is make sure your house is in order. So, we talked about the formation documents and that kind of thing. So you want to, if you, first of all, if you hadn't gotten some things done, now's the time to do it. We can usually fix things for the most part, especially the more notice we have, the better. Get your ducks in a row with, we mentioned that all employees should have signed invention assignment agreements. Make sure you have all that paperwork for your employees. You have a good partnership agreement among the partners, or shareholders agreement showing how money is distributed. So because the first thing that's going to happen when an acquirer comes in is they'll do what we call due diligence process. They're going to it's almost like an IRS audit, something like that. They're going to come and look at all of your legal docs, your financial docs, etc. So yeah, actually, I touched on the legal due diligence. Accounting due diligence is also probably the most important thing. There's something called what we call quality of earnings. So you can go to an accountant and they can do quality of earnings, which is a shorthand way of saying is how good are your books. And if they're not good, they can be cleaned up. That's what they're there for. So, and I've had a deal where somebody was about ready to sell their business, buyer was ready to go, and their books were terrible, and they had to do quality of earnings, and it took 3-4 months. They paid a bunch of money, but ultimately they after that was all the dust cleared, they were still able to sell the business. If it's if you do too bad of a job, they might walk away. So if you just do things correctly from inception to the end, that's always the best. But if you don't, come to us as soon as possible so we can get things cleaned up. That's the kind of due diligence side. On the sales side, there's a lot of different ways to do that. From a practical standpoint, if you're in a very isolated industry, very small group, you can maybe just go out to other bigger players in the market, see who's interested. You have to be very careful. You want to have an NDA signed so they're not just going to steal your ideas and walk away. But otherwise you might want to hire an M&A broker. There's brokers who, kind of like a real estate broker, who know the market. They have books. They'll help you kind of put together a presentation and go and find those buyers. Usually that's somewhere they charge anywhere from this is a very broad range, like 4 to 10% of the sale price, and sometimes there's like a cash fee as well. But depending on your situation, it might very well be worth it. So so that second step is finding your buyer. Then once you do that, you'll negotiate. You have the NDA we mentioned. You'll negotiate the LOI, letter of intent. That's super important because what happens is the sale documents can tend to be very long. For a really small, easily negotiated sale, it could be 20 pages, but for 50 million, 100 million, whatever sale with big law firms involved, it could be 200 pages. So, but the good thing about the LOI is it's usually 1 to 5 pages. So that's where you really want to get that right, because if you get that right, you're going to have less fights over the rest of the stuff. The fights you're going to have are over the long form documents and about due diligence. So if your house is in order and you have a good LOI, you're going to make that whole legal negotiation process a whole lot easier.
Yep, absolutely. Yeah, couldn't have said it better. Making sure you have everything in order from a legal and finance and accounting perspective make your life a lot easier, and also to maintain the value that you agreed on. We've seen too many times where businesses don't have the right legal documents, so they don't have the right protection, so they take a hit on their valuation, or their books aren't in order, and the numbers that they represented to the buyer either overinflated or need adjustment, which impacts valuation as well. So making sure you have that set up before you start that process is definitely recommended. So well said, Jason. Now, just want to wrap it up here on some advice and recommendations for business owners. So many business owners start their businesses, and they'll say, "Oh, I don't. I'll call an attorney when I need it, or when they're in trouble." Sean, just general high level. What do you recommend for small medium-sized businesses or startups? When should they engage with an attorney, and how often should they be talking to their attorney?
It depends on the business, and it depends on the risk appetite and the objectives of the business. But to answer your question, I would say generally, before you start the business, have that conversation early on. Have a relationship, an ongoing relationship with a lawyer that you trust. That is, just an open dialogue. I don't think companies need to be interfacing with their legal counsel on a daily or weekly basis. And to me, it's all about finding the balance between diligence and efficiency. And what I mean by that is, you want to you want to protect yourself. You want to be thorough in documenting your transactions, documenting the ongoing operations of your business. But you also want to make sure that you have lawyers who are mindful of where your business is and what your budgetary constraints are. We could look at a simple agreement and spend 50 hours on it and turning a 3-page agreement into 50 pages. But typically depending on what it is, we're going to look at it and say, well, that doesn't make sense here. That's not an efficient use of your time or money. It's really, to me, about finding that balance, having that conversation early on, and making sure that you're working with people that are being honest with you, that you trust.
Awesome. That's really well said. So that's about the time that we have for today, but I'd like for each of you to kind of give me an opportunity to tell us if there's any parting advice you have for business owners, or things you're seeing a lot of now that you want to make sure that anyone listening to this podcast keeps in mind. Jason, is there anything that comes to mind?
Yeah, absolutely. So, we usually focus on the legal because that's what we do. But I'd say, when you're starting a business, make sure you have before you dive into it, make sure you have a good product market fit, especially in the tech world. We see people kind of, fixing a problem they think people have, but they really don't. So do some good research into what your idea is. How much is it going to cost to build whatever this product is? Make sure you have a path to success so you're not wasting your own time and money. On the legal side, you're going to have budgetary concerns in the beginning. So like I mentioned, at the very minimum, just go to Sunbiz and get yourself, form yourself a company. I prefer that you start with legal and tax advice to, make sure you're in the right entity type and all that. But at the minimum, make sure you're operating under some kind of entity with liability protection. And, actually, as you alluded to earlier, Jeff, be cognizant about the cap table. If you're going to have 3 founders and a few key employees, you can't give 10 people 20%. You have to figure this thing out ahead of time so you're not all squabbling later. The sooner you kind of tackle these organizational problems, the better.
My only parting words are tax advice. Go talk to someone like Jeff or Larry at ProSear. Talk to whoever your accountant is. Get good tax advice from the onset of running a business. Understand what type of entity you want, that makes the most sense for your type of business. Make sure that you're keeping really accurate books and records. Make sure you're filing your tax returns. These are the type of ongoing compliance issues that people get themselves in trouble with. So I think it makes a lot of sense to go, get a good accountant and a good lawyer from day one. You may not even need a ton of legal and accounting services at the beginning, but it's good to establish those relationships, have those conversations, and then you have someone ready to go when you do need those services.
Sorry, I couldn't have said it better myself. It was on mute there.
I wasn't sure if it was just me not hearing you or not.
No, sorry. Definitely going to clip that, Sean, and appreciate that. So, Jason, where can anyone watching this who's interested in learning more contact you guys in case of any legal needs or interested in the topics we discussed today?
Yeah, absolutely. Avid.law. I'm Jason at Avid.law, Sean at Avid.law. So reach out anytime. We're always helpful, always happy to talk to people, even if You might not need help at that point, whatever. We're always happy to kind of steer you in the right direction. As Sean mentioned, get you the right tax advice, an accountant, get that process set up. So yeah, absolutely.
Fantastic. And Sean, are you guys active on social media at all? Any plugs there?
We're somewhat active on LinkedIn. You can find us, get it Avid Legal, and all of our social media links are on the website, which is Avid. It's AVID.law, LAW.
Fantastic. Well, thank you guys so much for taking the time today. Really appreciate the expertise you shared, and I know it's going to be valuable to all of our viewers. So if you're interested in learning more, reach out to Jason and Sean or us, and we'll be happy to make an intro. So thank you guys a lot, and stay tuned for our next episode coming probably in a month. All right, talk to you guys soon.
All right.
Awesome. Thanks, Jeff.